thank you for joining us tonight. My name is Linda Halloran. I'm the Community Engagement Manager with Town and Country Federal Credit Union. We're glad that you're here tonight for our first financial wellness session of 2022. Tonight, we're talking about long-term care. And we all know that long-term care, assisted living, nursing facility, nursing home care, in-home care can be expensive. And oftentimes, planning for long-term care for ourselves and family members is something we put off because we're not sure what to do, where to start, and don't always understand it. To help us better understand long-term care and ins and outs and challenges of that, we have invited attorney Miles Hunt to join us tonight. Let's welcome Miles Hunt.
Kind of the first thing we're going to talk about are the basics of Medicare and Medicaid coverage and eligibility and how you become eligible for things like Medicare and Medicaid. They're often confused, so you'll walk away at least knowing the difference. We'll talk about different types of long-term care, like what does long-term care actually mean? We're going to distinguish the difference between crisis versus pre-planning for long-term care. There's a big difference between the two. We'll talk a little bit about estate recovery. Some folks might have heard, how does estate recovery affect my family and after their death? And then we'll talk about what I think most people are here to kind of look at is what asset protection strategies are there? What can I be doing, or what should I be talking about or considering, and when? And we'll talk about other planning tools that folks have in considerations when we start talking about end of life planning, long-term care planning, and helping out your families. So first things first, when it comes to Medicare, Medicare is just a federal insurance program, and you automatically qualify if you're over 65. There are certain younger people with disabilities that can qualify for it at an earlier age, and people with end-stage renal disease. There are different parts of Medicare, and I've got a little demonstrative card up there in the upper right-hand corner. And Medicare Part A essentially covers your inpatient hospital stays, some skilled nursing care. We'll talk a little bit about that. Covers hospice care and some other healthcare needs, but you have to formally be admitted to a hospital with a doctor's order to get the inpatient treatment. Then there's Medicare Part B, which covers more of your essential doctor services and annual physicals and tests and outpatient care and labs and medical supplies and things like that. Some people will qualify for Medicare Part C, which is a supplemental plan, and it provides more coverage for an additional cost. So it's kind of an opt-in, more platinum version Medicare, if you will. Medicare Part D just adds a prescription drug coverage to your original Medicare and some other cost plans that are out there. And there's some Medicare private fee-for-service plans that will allow you to add in the Medicare Part D. So those are the four major parts of Medicare to consider. Then a lot of people have what's called Medigap Insurance. And this is extra health insurance that you'll be looking at buying when you retire, or even leading up to 65 if you're continuing to retire. And basically you're just buying this from a private company, and it's paying for healthcare costs that are not covered by Medicare, like your copays or deductibles, or if you travel outside the US, healthcare outside the US. And the average cost of most Medigap policies is going to range from like $50 a month to $300 a month, depending on the types of policies that you've got. The federal government, in an effort to kind of give more guidance on this, standardize the types of Medigap plans, and not to complicate things, but they created 10 different options, and the designations are below. And when it comes to Medigap policies and Medicare, and when you're kind of nearing in on retirement, I highly recommend that you look into some of the resources that are available for shopping around for what Medigap policies might be good for you. There are plenty of nonprofit groups and for-profit advisors, professionals that will help you navigate the different options that are out there with you. And I just give you a couple examples up there, like Seniors Plus or Southern Maine Agency on Aging. You can literally reach out to these places, and they have professionals that will help you shop around based on your needs and what yours and your spouse's needs are. So I highly recommend this, especially if you're nearing the end of your work and nearing in on 65, where you're going to have to start making these decisions. So what isn't covered by Medicare? Because that's kind of the big question. Well, Part A, which if you remember is what covers your inpatient hospital stays and some nursing care stays, it's only going to cover it if you have a qualifying inpatient hospital stay. So you have to go into the hospital for at least 3 consecutive days, resulting in a formal admission written by your doctor. And after that, if you've done that and then you transition to a rehab or a long-term care facility, Medicare is going to cover everything for 20 days. And then you would pay a certain amount per day over a certain amount of time. So usually those at most are going to cover 100 days. So if you can imagine about 1 to 3 months are going to maybe be covered by Medicare if you ended up in a facility. And so that's something to keep in mind. On Part A, there is no charge for hospice care other than your copayment for medication and inpatient respite care. Hospice care is when you have been designated to you're only going to live for about 6 months or less. So once they've made that designation, you qualify for hospice, and whether you're receiving hospice care in a facility, a hospital, at home, in a hospice house, something like that, that's going to be covered by Medicare. Costs for hospital services under Part A are $1,316 for up to 60 days, or $329 a day for 61 to 90 days, and then $658 per day for stays beyond 91 days. For the most part, dental care, eye exams, hearing aids, acupuncture, and any cosmetic surgeries are not going to be covered by Medicare Parts A or B. So much like when you're working for a private employer, when dental care and those things aren't covered, you're going to pay out of pocket for those. But most importantly, aside from the very short period of time that I've outlined here, that approximate 100 days, long-term care is not going to be covered by any part of Medicare. So what are the different types of long-term care? Well, most people, when they think of long-term care, they think of just nursing home, but there's lots of stages leading up to that. There's supportive and respite care, which is, maybe it could be anything from family and friends coming in to cook you meals and clean up a little bit, maybe help you get dressed, take some medications. There are all sorts of private care services or nonprofit assistance that you can get for supportive care. And a lot of my clients might hire friends or family, to do this for $15, $20 an hour, $25 an hour. I will tell you that most private care services usually range anywhere from $25 to $40 an hour. And they're typically not someone who's receiving supportive care isn't getting more than, they don't need nursing care. They just need someone to kind of come in, check in, help them clean up, maybe take them for errands, things of that nature. Then there's home and community-based services. And sometimes Medicaid, here in Maine, we call it Maine Care, is going to pay for care in home or in assisted living if it can be obtained at a lower cost than in a nursing home. So this is essentially if you just need a couple hours, maybe a week or a couple times a week to have somebody come and provide some services in your home or in a community-based setting, that's a Medicaid program that's available. Then we scale up to assisted living. Assisted living basically allows individuals to live independently. You're either in an apartment or a room, but you're going to receive some services, usually meal prep, homemaking, personal care, medication administration. These are not usually people that need high-level nursing care. This is not where you go necessarily when you have advanced dementia or other impairments that are going to prevent you from living independently. Then we have residential care, where you are getting more shelter and personal care services than assisted living. But again, typically that's non-medical. It's just more maybe memory care stuff where you have people that will help you navigate the rest of your day, but not ambulating to the bathroom, taking showers and things like that. That's when we get to nursing home care. This is the highest level of long-term care. It's non-inpatient hospital care. Typically, it includes a professional nursing or rehab service for injuries, disabilities, or sick persons, and it's needed on a daily basis. And it's usually assessed based on your activities of daily living, what we would think of, maybe as, being able to go and take your own shower, dress yourself, or ambulate from one place to another. So those are really the big long-term care options that are out there and available to people. So what are the options for paying when Medicare won't? Well, right off the bat, if you don't qualify or you don't have long-term care insurance or any other benefit that's going to pay for it, you're stuck with private paying. And the average cost for assisted living right now, I think, is usually somewhere in the $4,000 to $7,000 a month, and the average care for cost for nursing home care is between $8,000 and $12,000 a month. So it's expensive. And I've had some clients that wanted to stay at home and had the financial resources to do so. So for in-home full skilled nursing care, it's far more than even a facility care. You're usually looking at, $15,000 to $30,000 a month if you need someone round the clock that's a nurse. So long-term care insurance is an option. You typically need to buy long-term care insurance earlier in your life. It's something you pay and you get it at an early age when you don't have a lot of health issues, and you pay for it through your lifetime. And hopefully at the tail end, if you need long-term care, it'll pay out. It can be very expensive, but depending on circumstances, it can be attractive for certain individuals and families. And what I like to tell people when you're looking at long-term care insurance is it's not something you need or want if you don't have a lot of assets, because again, it's expensive. It's a heavy annual premium, but it's also not for people that have so many assets that they're not concerned with paying, $50,000 to $150,000 a year or whatever it is going to be for their care. But it is something you should think about at an earlier age. I would recommend talking with a long-term care insurance agent, one that we frequently see presenting and who would be open to discussing options is Carrie Peabody at Clark Insurance. But a lot of people have financial advisors that can talk about that. Be wary sometimes of the hybrid policies. There's all sorts of things out there, and not every long-term care insurance policy is going to be the same. Certainly the one big thing I like my clients to ask the agent that they're buying it from is will this pay for my home care? Will it pay for care in home? Will it pay for supportive care? So as soon as I need somebody to come in and help me, a couple hours a day, is that something that my long-term care insurance will cover? And certainly there's a concern about rising premium costs. That's why a lot of people are avoiding this currently, because long-term care insurance companies are jacking the prices. So I'm not a long-term care insurance expert. I certainly have clients that have had long-term care insurance and it's worked out. But again, it's one of those things that if you don't go into long-term care, you could be paying a long, long time and never use it. But that's the case sometimes with a lot of insurance policies. So if you can't private pay, and if you don't have long-term care insurance, that's when Medicaid and main care eligibility is a potential option. I like to think of it as a safety net for those people that can't private pay because they don't have enough money, or those who don't have the coverage. If there are very strict eligibility requirements, and we are going to talk about those, and there's a burdensome application process to get on that. But when you hear about Medicaid, main care, 5-year look back period, state recovery, this is the program we're talking about. So with respect to medical eligibility, there are usually functional assessments that get done to help individuals and their families identify what services are available to them based on what their needs are. So I have a little chart there on what types of activities of daily living get assessed. There's a medical eligibility determination form, which is a tool approved by DHHS in Maine to determine your eligibility for in-home or long-term care services. These used to be assessed by what they call Gould. So you might have heard the term a Gould or a KEPRO assessment, but now they're completed by a contracted agency, I believe most recently by Maximus. So if you apply for Medicaid or main care, they're typically going to do a Maximus assessment first to determine what level you're eligible for. And then at that point, they'll look at financial to see if you're eligible for financial. So again, the types of things they're gauging are, can you bathe, dress, get around at home, toilet, eat, can you take your own meds? Can you prep your own meals, shop? It's pretty straightforward, in those terms. Someone had asked a question, Jessica had asked, can I discuss the recommended period of time to cover when considering long-term care insurance, or would someone like the person at Clark advise us? I think, as with any insurance, if you're looking in the 35 to 45 range, starting to consider if that's something you want, because the older you get, just the more expensive the premiums are going to get, and the less likely or more likelihood that you may not qualify for long-term care insurance. But certainly something that you could pick up by calling, Carrie or another long-term care insurance agent, say, when should we start thinking about, doing that? So once you've been determined to be medically eligible for a Medicaid or a main care program, we look at financial eligibility. And unlike Medicare, you do not need to have any work history required for the Social Security, retirement, and disability programs that Medicare has. Main care covers more services at less cost than Medicare. And full benefit main care provides comprehensive health coverage with no deductibles or premiums and small copayments. But you have to have low income and limited assets to be eligible. Adults age 21 and over with income up to 100% of the federal poverty level after certain deductions may meet the assets test and other requirements, and you can be eligible. I give you some stats down there as far as what your income would need to be for institutional or nursing home care. So if you're a single individual and you're making less than $2,382 per month and you have less than 10,000 in countable assets, you could be eligible for main care. So as I'm working through this and I'm talking about the $10,000 mark, that's what we're talking about. You have to spend down below $10,000. Another thing I like to point out is that when you're dealing with a husband and a wife, or a married couple, I should say, the spouse who's going into the facility, we call that the facility-bound spouse. They're the ones that would have to have under $10,000. The spouse who's not going into the facility and maybe is remaining in the home or in the community, we call that the community spouse. They're allowed to have an extra $130,380 in liquid assets or countable resources, and we'll get to that in more detail. So what are countable resources for eligibility purposes? Well, essentially, everything you or your spouse own that are not exempt: cash, stocks, bonds, investments, checking, credit union, savings accounts, real estate, life insurance, cash value, annuities, retirement accounts. Anything that you have that can be liquidated and expended is accountable resources. But there are some exemptions when it comes to eligibility. The most important one is the primary residence. You can have a house and still qualify for Medicaid or main care, long-term care. You can have one vehicle, and two if there's a specific purpose for one of the vehicles. For example, if you had a plow truck, just for plowing, they'd probably allow you to keep that. You're allowed to have a mortuary trust, which is just prepaid funeral expenses that you've paid to a funeral home to go into a mortuary trust. They don't really get too trumped up about personal property or belongings, so you can, have all the contents of your home to your heart's content. They don't make you sell every last, dish to pay for your care. And then up to $10,000 for the applicant. And I haven't updated this from 2020 eligibility, but it was $130,380 for the community spouse. So as between spouses, you could have approximately $140,380 and a house and a car and get one of the spouses eligible for main care. Okay. If you had both spouses going into long-term care, you'd have to spend down, I think it's to $15,000 or less total between the two spouses if both spouses go in. So that's what you're allowed to have. If you have over those amounts, you won't qualify for main care, and they will make you private pay for your care until you get below those thresholds. All right. So what is crisis planning for main care versus pre-planning for long-term care? Well, essentially, if a spouse or a loved one is about to go into a nursing home or is already in a facility, you are in crisis planning stage because you haven't done any planning. You already have somebody who's in there. You're already going to be looking at private paying or potentially trying to manipulate the assets in a way that gets you under the eligibility amount guidelines. And usually at that stage, there's just fewer options for asset protection strategies, especially if you're unmarried, because you can't do any transfers to your spouse or buying any Medicaid annuities and things of that nature. Oftentimes, the only options are if you have any exempt transfers, and we're going to talk about what some of the exempt transfers are later, or purchasing a Medicaid compliant annuity. And this is very complex stuff. I would not recommend that you do any of this on your own. You probably can't. It's something you'd want to go and see an elder law attorney specifically who handles crisis planning stage. And there's a question about how does one reduce the value of the home? Your home is what the home is. As far as a value perspective, whether it's $500,000 or $200,000, it doesn't matter what it's worth. Your home is going to be an exempt resource for eligibility purposes, which means you can have a home and be eligible for main care. We're going to talk about what happens after your death, but as far as getting eligible, you can have a house. Leading up to the crisis planning stage, you are going to be in varying degrees of pre-planning. there are more options for asset protections available with different levels of risk depending on a number of factors: how old you are, what your health is like, what your family dynamics are. We're going to get into some of those details later on. If you're over $900,000 for the value of the home, you know, I think it largely depends on what MaineCare asks for. If you have for example, a $1.5 million home on Sebago Lake and it's just there because it's on the lake, maybe you get an appraisal that would value it at less. Maybe the tax assessed value is less than 900. But that's something you just have to work through with the caseworker for MaineCare if you're applying. There's nothing you can do to reduce the value of the home. It's valued at what it's valued at. I want people to walk away from here understanding what the 5-year look-back rule is. Essentially what it is any transfers that are made for less than full consideration will potentially trigger a penalty period for the applicant, the MaineCare applicant, if made within 5 years of the application date. So if I transfer assets away, let's say I gift $100,000 to my children before I get sick, and then I get sick, I go into a facility, I apply for MaineCare. MaineCare is going to look back. DHHS is going to look back 5 years, and they're going to ask me, have you made any transfers in the last 5 years? And I will have to say, yes, I transferred $100,000 to my child, and they will potentially assess a penalty period, which is just a period of time where they will not let me be eligible for MaineCare. And so that 5-year look back period is really important, because this is what prevents you on the eve of going into a facility of gifting all your assets away and then saying, I don't have anything, and qualifying for MaineCare. And they do get very detailed. They ask for 5 years worth of bank statements from any account that you have. They ask for information from life insurance companies, retirement accounts. So they are looking, and they will go line item through to determine if there's anything, you know, that seems out of place. You know, if there's all of a sudden a $50,000 cash withdrawal, they'd want to know where what that was and why you did that. And really, the public policy behind that is what I just said, is if they don't want people to get close to a nursing home facility and then transfer everything away, and then all of a sudden we're on MaineCare taxpayer dime. So examples of this could be transfers of real estate, cash, giving cash to individuals, or helping others pay for things. I once had a woman who was helping her daughter, or her granddaughter, I guess it was, pay for daycare expenses for her great-granddaughter, and had paid for that for several years. And MaineCare actually looked at those payments as gifts, and they assess a penalty period. And basically the way they calculate the penalty period is they take the fair market value of the gift that was made. So let's say it was a $200,000 piece of real estate, and they divide that by the average monthly private pay rate for the state of Maine. And I think it's right around $8,500 right now here in Maine. So again, if you took out a calculator and you divided 200,000 by 8,500, that number that gets kicked out is how many months it would take before you become eligible for MaineCare. So it's a significant penalty. You could be left with no money, not eligible for Medicaid, and the facility may not accept you, or they may undertake eviction proceedings, for lack of better terms, to get you out of their facility because you can't pay and you can't qualify for Medicaid. Okay, so that's the 5-year look-back period. When we start talking to clients about what options are available to try to protect assets, first thing we look at is whether there are any exempt transfers. Transfers between spouses are exempt. So if only one spouse is sick and the assets are pretty low, we might consider transferring everything into one spouse's name who's not going into the facility, getting the facility-bound spouse on MaineCare. And then once that happens, the other spouse, the community spouse, can continue to use the money or the assets like they always have. And they may even undertake more planning to gift things away, you know, before their 5-year look-back period is over. I have a lot of clients that have disabled children, or you know, adult disabled children or minor disabled children. And one of the options that's available is to transfer a home or other assets into trust or outright to a disabled child. MaineCare will allow that transfer to happen. If there's a sibling of the applicant with an equity interest in the home, like if siblings were living together, for example, and they co-own the property, if they've been residing at the home for at least a year before the MaineCare application, they would let you transfer it between siblings. A transfer to a caregiver child who resided in the applicant's home for at least 2 years immediately leading up to the institutionalization, and whose care allowed the parent to stay out of the institution is allowed. In layman's terms, if I move in with my parents and I take care of them for 2 years, and that care was needed in order for them to not go into a facility, MaineCare would allow a transfer of the home to me because I moved in with them. That has to be a child. It can't be a stepchild. It can't be a grandchild or a friend. It has to be a child moving in with the parent. And that's different than the parent moving in with the child. They don't allow that transfer if you just bring your parent in and then all of a sudden you want to transfer their home to you. So those are very strict rules. And then assets transferred to a trust or directly for a disabled individual, I think we touched on that, is exempt as well. Real quick, want to talk about estate recovery, because I mentioned that in order to become eligible for MaineCare, you can have your home and up to $10,000 and a car. After your death, however, if your estate gets probated, or if there are assets still in your name, and if you had previously been on MaineCare, or at least a MaineCare program that allows for estate recovery, that means that the state can come in and file a claim against your estate to get paid back. And what MaineCare does, what DHHS does, is they keep track of everything they pay, whether it's $8,000 a month to Norway Rehab, or $50 for a certain prescription, or whatever it might be. And at the end, they total it all up and they will file a claim against your probate estate. And that's the point when the house would, if it hasn't already, the house could be forced to be sold to satisfy that MaineCare claim. So it's a kind of a big myth that the state will take your house. They don't take your house, but they will file a claim, and they will potentially force the sale of assets if you have them left after your death, in order to pay the state back for what they paid for. It generally only arises from MaineCare benefits that are provided by the state for individuals who are 55 and over. And the state is recently changing. In fact, I got a bunch of letters just here today and yesterday. The state's changing what programs they potentially are seeking estate recovery for. And it looks to me like they're just going to go after estate recovery for people who get nursing facility care, assisted living residential care, nursing facility care, or in-home care, as opposed to just the general MaineCare program. But yeah, any probate assets that the decedent has who was on MaineCare is subject to the claim, and any assets that they have to be used to satisfy that claim first. There's really no getting away from it. There's little to no room for negotiation, although, sometimes depending on the value of the property versus the value of the MaineCare claim, we can negotiate some type of deal with them that everybody's happy with. Federal law kind of lays out the Medicaid regulations regarding estate recovery, but doesn't require states to pursue certain recovery from non-probate assets like jointly held bank accounts or jointly held real estate, trusts, retirement accounts, things like that. But Maine's estate recovery law provides full authority essentially for the state to pursue all probate and non-probate assets. The state it depends on, sometimes what casework you're working with or how aggressive the state is working at the time, what they will actually go over after you have passed away. So what options do you have other than buying long-term care insurance? Well, you could do nothing. You don't have to take any measures to preserve your assets from long-term care. You just kind of have to be aware that if you take no action, and if you have assets, when you do go into a facility, you may be required to privately pay for your care, sell real estate, sell rental properties, camps, liquidate your retirement account, cash out your life insurance policy, and spend everything down until you get below $10,000. And at that point, once you've spent everything down below 10, you can qualify for MaineCare. And I have to be honest, I have some clients that they're perfectly comfortable with that their own comfort, their own control outweighs wanting to try to protect assets for their family members. So you could do nothing. You could consider if exempt transfers are an option. We covered those, and of course you would want to chat with an attorney to see the best way to do it and how we go about doing that. You could consider outright transfers to individuals, just getting the assets out of your name at least 5 years before you try to apply for MaineCare. Again, that 5-year look back period comes in. So if I wanted to deed my camp to my 2 children and get it out of my name, and I do it at least 5 years before I apply for main care, 1, it would not impact my eligibility for main care, and 2, it won't be subject to any estate recovery. It would just be in the kids' names, no problem. The things I want people to consider, though, before you start deeding properties and gifting money away, is you have to assess whether there are potential capital gains tax issues. If I have a camp that I got back in 1970 on Sebago Lake for $50,000 and now it's worth $1 million, I don't necessarily want to go giving that away, because we might lose a stepped up tax basis. There might be considerations there to think about. There's also loss of control. I mean, how many people, if I asked today, would be comfortable just deeding their house to their kids and leaving it up to their liabilities? You know, if you deed a property to your son and he dies, or if he gets sued or divorced or gets into an accident or something happens, consider concerns about that and the liability that might fall out of that. Oftentimes clients don't think 2 or 3 steps down the road. You know, so these are the types of reasons why you'd want to consult with someone like me or another elder law or estate planning attorney, just to consider the ramifications of what you're doing. I am going to get to trusts and LLCs and corporations and stuff like that. I am going to get to that. So hang on there. You could take a wait and see approach, where you kind of just not take any measures right now, but you know, maybe you have enough assets that you can wait and see if you go into long-term care. And if you do, you've got enough money to private pay for a period of time, but still protect, you know, really important assets like real estate or camps, things like that. If you want to do that, I'd strongly consider that you have a really good power of attorney that authorizes gifting and transfers in the future. A lot of times people do last minute planning called reverse half a loaf, which is a really complex plan where you gift certain assets away, take a penalty, receive half the assets back, and buy an annuity to private pay during the penalty period. Don't do it without the benefit of a really experienced elder law attorney doing the calculations, because again, it's very complex. Without getting into too much detail with that reverse half a loaf planning, at that point, you're kind of trying to protect about half of what you have left from long-term care costs. It's currently allowed by DHHS. One thing I always give a caveat on is, you know, it may stop working at some point. DHHS certainly has the ability to try to find a way to make a strategy not work. So just be careful. Transfers into irrevocable Medicaid compliant trusts. This is the one that I primarily do the most of when I'm doing this planning. What this involves is basically taking the real estate or the asset you're trying to protect and transferring it into an irrevocable trust that you are not the trustee of, you are not really the beneficiary of, although you could be an income beneficiary. And again, what it does is it gets it out of your name and starts the 5-year clock ticking. What are the consequences? Well, you lose control. So you no longer have access to sell the home, mortgage the house, you know, transfer it. You know, it's no longer your home. It's now in the trust under the control of the trustees. The 5-year look back period is still an issue. So from the date you transfer it into a trust, you'd have to wait 5 years before you're eligible for main care, because they would look back and see the transfer into the trust as a countable transfer. There's always concerns about the trustees you choose and their management of the assets. Again, you're not in control of that anymore necessarily. A lot of people will name their children or other trusted family members to be the trustees, but even then, family dynamics can change. But what are the benefits? Well, you could retain the rights to just the income while protecting the principal. So let's say I had $500,000 in a brokerage account, and all I really want from that is the stream of income, but I want to try to protect the $500,000. I could put that $500,000 into the trust, retain the right to the income, but main care wouldn't be able to go after the principal if I later went into a long-term care facility. By transferring it into an irrevocable trust, you know, depending on how it's drafted, but you can have a lot of protections from liabilities and creditors and divorces of other families. So compared to a transfer outright to your child, if you put it into the trust, if that child gets into, you know, has a divorce or has a financial liability or something along those lines, it will be unaffected inside the trust. So the trust is a preferred method for protecting it from liabilities and other things like that. In the trust that we draft, my clients retain what's called a power of appointment, or a power to appoint where the trust assets go. So even though we might start out with the trust distributing out to their kids equally when they die, if situations change and my clients want to adjust that, you have the ability to change where the assets go in the trust after you die. A lot of times, especially if we're transferring real estate or seasonal residences into the trust, my clients will retain what's called a life lease, not a life estate, but a life lease in the residential real estate, which gives them the right to exclusively use and occupy the property for their lifetime. As long as they pay the taxes, insurance, utilities, they can stay there. That's what gives my clients the comfort that their kids can't evict them or in any way lose their tenancy, and also allows my clients to continue paying for things for the house like they always have been. So that's something that we usually do. The cool thing about the irrevocable trust, the way at least we draft them, is that we draft them so that the assets that are in the trust still get the stepped up basis when the settlor dies or when the client dies. So if I moved that camp on Sebago that only cost me $50,000 into the trust, when I die and it goes to my kids, if they get it appraised, whatever it appraises at will be the new tax basis. So later on down the road, if they sell it, they wouldn't pay as much in capital gains tax if they went to sell that. So that stepped up basis is a really important thing to consider. The other thing I like about the trust is it allows my clients to provide for more remote contingencies if their original beneficiaries die. So if I compared it to me gifting a house to my son, if my son dies, that's kind of it. It goes through his estate and I can't redirect where it goes. If I put it in the trust and originally it's set up to go to my son and he dies, well, I have other contingencies built in on where I want it to go when I die, as opposed to my son's estate controlling that. Someone says military only had a 3-year wait period. I'm not familiar with that. Usually military stuff is governed by the VA benefit plan, and VA benefits are a little bit different. And most people who were in the military would qualify to go into a VA facility. And a lot of times the VA facilities, depending on what your level of service was, and whether you were combat or disabled, will determine how much your benefit is to go into a VA facility. So, I don't do a lot with the VA eligibility and the VA benefits, but there are certainly attorneys that do help people access the veterans benefits that are available. I'm going to get to later down the road some of the costs associated with doing this planning. As far as the process of establishing and funding it, be really careful who you hire to draft these. First of all, don't draft these on your own. You could screw that up. And the selection of the attorney, whether it's an elder law attorney or trust estates attorney, is really important. You have to make sure you get someone with experience drafting these Medicaid compliant trusts. I can't tell you how many clients I've had come in with a trust that somebody drafted for them 5, 10, 15 years ago, with the understanding that they thought they were protecting the assets. That's what the attorney told them, but the attorney either screwed something up in the drafting or didn't really understand it. And I ended up having to start the process with them all over again because they didn't start the 5-year clock appropriately. And really work hard to identify whether there are appropriate assets to transfer into the trust. It's not a great tool for retirement assets because in order to put a retirement asset into an irrevocable trust, you'd have to liquidate your IRA or your 401k, pay tax on it, and then put in the net proceeds. And for a lot of people, that's just not feasible or appropriate. So be really careful about that. You also can't put in real estate that has a mortgage on it. So if I have a house that's worth $800,000, but I still owe $200,000 on it, I can't put that into an irrevocable trust because the bank could call that note full and create all sorts of problems for me. The best assets to consider putting into an irrevocable trust are things like camps, fully paid off primary residences, maybe timber lots, rental properties, cash, other liquid assets like brokerage accounts, stocks, bonds, mutual funds. Those are the types of things that are easy because you just kind of pick them up, move them, and sit them down, and they just sit there until you die. But I always counsel my clients to really try to strike the balance between your own needs and what you want to protect. You don't want to give everything away and potentially not have enough to pay for your needs. So we always talk about how much are you comfortable putting in, what assets are you comfortable putting in, et cetera. But once you've drafted the trust, once you've selected your trustee, and usually I recommend 2 or more individuals, and a lot of times that's going to end up being the children or the siblings of the parent who's trying to protect the asset. Once you've done that, we execute the trust and then we fund it immediately. A lot of times that might be by signing a deed. The date the deed is signed for a piece of real estate is the start of the 5-year clock ticking. The date that you move the assets from a brokerage account into a trust account under the tax ID number of the irrevocable trust is the 5-year look back period for the brokerage account. As far as the cost of setting these up, guys, it can vary greatly. You know, I've heard some attorneys that will charge $15,000 to $30,000 for this. I mean, astronomical. You know, most of the ones that I do when I do this level of planning, it's usually running somewhere in the $2,000 to $3,000 range. But you'll hear everything from I'll do everything for you for $10,000 or whatever to, you know, I'm sure there are some people that are promoting this for a couple $100s. I would be very leery of attorneys who are quoting a couple $100s to try to protect your assets because that's just not typically reasonable. Somebody asked whether home equity loan are mortgage. If it's secured on the property, that is a mortgage. And the bank, likely, if you looked at your note or looked at your mortgage, the bank could call that note in full at any time and make you pay it all off. They could cause real problems. So I certainly, if you had an attorney, you know, who advised you to put a house like this into an irrevocable trust with a mortgage, you know, if the bank doesn't find out, I guess maybe you won't have any issues, but it could potentially pose a problem down the road if they do a title search and maybe update their policy, their mortgage. That could be a problem. The other thing that we look at a lot, the other tool that we look at is private caretakers and personal care contracts. I mean, let's say I just want my mom just wants my sister to take care of her, and my sister's perfectly happy to quit her job and move in with mom and take care of her. I mean, these happen all the time. And unfortunately, a lot of clients do it for a long time before they come and see me, and they just pay their children under the table, give them cash, and, you know, pay for their gas and all these other weird setups that I've seen. And that's not great, because if there ever comes a time where you have to apply for main care could potentially look at all those cash transfers and things that you've done to your kids as gifts, and that could assess a penalty period. So what I typically say, especially if I get people on the front side of this setup and I'm meeting with the parents and the kids, is I say, have you considered just doing a little personal care contract that says I have agreed to pay my daughter $25 an hour to provide these services, and those work really well. The things main care is going to ask for, if you later have to apply and prove that they were payments for services, is there should be a letter from the doctor, from the primary physician, saying that you need someone to care for you in order to remain independent and at home. You know, Jane Doe, she needs her daughter, you know, Susan Doe, to move in with her or provide care in order to keep her independent at home. You have to have an executed personal care contract. It has to be in writing. It can't be for care provided in the future. It has to be paid for now, and compensation has to be reasonable. Usually reasonable can run anywhere from, I don't know, $15 an hour to $35, $40 an hour, depending on the level of expertise that the caretaker is going to provide. There also has to be proof that payment for services were made at the time they were provided. So you can't take care of your parent for 3 years and then all of a sudden pay back 3 years worth of care. You have to kind of do regular payments and invoicing. And it often, when you have these, they have to be supplemented when we apply for main care with proofs showing that it was income to the child, you know, whether they claimed it on their income tax return or that they for whatever reason didn't file it on their tax return, but they typically ask for a lot of documentation. Other planning tools that I want people really to think about are advanced healthcare directives and POLST forms and DNR orders. Those are less for the asset protection side, but just more for, you know, advanced planning for long-term care. You know, a lot of people are prepaying and pre-planning for their funerals now as a really effective tool to spend some money down, but also have it all done and over with. So their family just have to pick up the phone and call the funeral home and everything's been done and planned for. A lot of times we do rental agreements. So if you have a parent that moves in with you, you know, maybe they pay you rent, you know, for the ability to stay there. But again, it should be documented, and a rental agreement, although it might seem awkward to do that with a family member, can be really important. Sometimes people will do promissory notes and mortgages to elderly folks for their care or their housing costs. So if I'm going to private pay, for example, for my mom's care, I might take out a mortgage on their home, to private pay for that. Jointly held assets or real estate held solely in the name of an elderly person that are not theirs. That's a common occurrence. For example, if mom owns the property, but the house is being lived in by their children, that's not a good setup. If mom goes into long-term care, that child will have some problems if mom has to go into long-term care. I've done divorces with couples where one spouse is going into a facility and maybe the other spouse has more assets. We've done divorces, especially if it was like a late in life marriage, just to try to protect assets of the spouse who's not ill. And then obviously we talked a little bit about long-term care insurance. The other last thing I wanted to mention on long-term care insurance, as I'm reminded by my slide here, is that Maine has a really cool program called the Long-Term Care Partnership Program, where if you buy a certain policy and it has to qualify under the terms of the program, you can qualify for double that amount in protection. So if I bought a $250,000 qualifying long-term care policy, MaineCare, not only will I be able to use that long-term care insurance, but MaineCare won't count the first $250,000 of additional assets that I have when I go to apply. So you basically are getting $500,000 worth of coverage if you do a qualifying program. Contact information's up here. Certainly if there are circumstances or if any of you want to do any planning, I'm certainly happy to address whether it's something I can take on. But there are plenty of other wonderful attorneys that do long-term care planning. And I just would say, make sure you really do your research like you do with any other thing that you do. You wouldn't have, someone that you don't know anything about work on your brakes for your car. So, certainly do the same diligence you would do for that. Thank you. So Stephen reminded me to talk about LLCs and corporations. So LLC shares and corporate shares are treated just like any other asset. So yes, potentially they can make you sell or liquidate the assets that are in the LLC in order to pay for your care. So if I, for example, owned, 100% of Miles Hunt LLC, which had my camp in it, but I own the LLC shares, they're going to make me liquidate that to pay for it. The LLC shares or the corporation shares themselves, what I've had a lot of clients do is move those LLC shares or those corporate shares into an irrevocable trust. Another question from the gallery here is, how long should a person pay for long-term care insurance if a person is in their 80s? I guess my answer to that question is you've been paying for it for a long time. You got a lot into it, and you're right at about the time when you potentially are going to have to start needing it. What I would say is I've had a lot of people who have taken their long-term care policies that they've had for a long time and gone to someone like, Carrie Peabody or other long-term care, trusted long-term care insurance agents just to look at the policy. Because I've been told and have heard Carrie present on this, there are options to transition your policy into a different policy, maybe cash it out and do something else with it. I would say, certainly connect with someone like Carrie Peabody if you have any questions about your policy or buying a policy or what the terms are, because I just really wouldn't know the details of long-term care. And I've already mentioned to Linda in Town and Country that potentially they could consider having someone like Carrie come and do a presentation on long-term care insurance. And when I say Carrie, it's Kerry Peabody, and he's a long-term care insurance and insurance agent with Clark Insurance, who has presented a lot to the estate planning seminars and things like that we've seen. And so typically I refer clients to people like Carrie to counsel on long-term care insurance. I don't really have any thoughts about the current Genworth situation. I just know that my take on long-term care and what I've always heard is that the insurance market, insurance companies missed the market when they started selling these long-term care policies years ago. They didn't realize how expensive that care was going to be. They didn't realize how many people were going to need that level of care. And that's why you're seeing some of these premiums get jacked, because the insurance company is paying out more than they're bringing in. The insurance industry is, as most people know, is interesting to deal with, and they usually are looking for every reason not to pay out. But it's typically different than life insurance because they had a lot of statistics to work on when they were quoting life insurance. They didn't have those when they were quoting long-term care insurance policies. So I think they just really missed the market. And that's why you see a lot of insurance providers don't even offer long-term care insurance anymore. They just got out of it. It just wasn't worth it to them.
Miles, question, where does somebody start when, if you're 40s, 50s, you've got parents in their 70s, how do you start the conversation in a family around a topic like this? Because this is, sometimes people go a long time and don't want to talk about these kinds of things with their kids.
It's a great question. And I mean, let's be honest, we're Mainers. I was born and raised here. Mainers can be very close-lipped, and unfortunately, the generation where a lot of this planning is being done right now, either grew up through, the Depression, they've hidden things away, they never talked about finances. So you're right, it can be very difficult. One of the best ways you could do it is say, hey, listen, I saw a great presentation by this attorney, and he had all sorts of, things that just started sending off red flags that we could lose our home, we could lose our camp, and maybe just prompt them to say, hey, listen, can you just go talk to somebody? I'll even pay for it just to go consider it. And usually I will tell you that when I get those people in the door, as resistant as they may have been for their whole life to not do anything, as soon as they start hearing the harsh realities from a professional that, how would you like it if your kids had to sell the homestead that you built or the camp that's been in the family for 3 generations? Because that's what we're talking about. I usually say this is a great springboard for people. Just to kind of educate, maybe lead them in the direction of looking at some of the materials that are available online for long-term care. I usually use any estate planning session that I have, like when clients come to me to do their wills or their powers of attorney and stuff. I mean, they usually get more information than they bargained for. If you've made it through this presentation, you can kind of see I lay on as much information as I can. But usually I like to spend at least 5 to 10 minutes with my clients who are over 45 or 50, just saying, hey, listen, what are your plans for long-term care? Are there assets that you envision in the future wanting to try to really make sure that your kids get or your grandkids get? Because if that's the case, circle back to me. Remember to circle back to me when you retire or when you are nearing advanced retirement age, so to speak, because we should have those discussions. And sometimes clients really want more information then, and I give them, a little bit more of what it would entail. I think encouraging people to do any level of estate planning with an attorney who will cover that, just so that it's out there. I mean, maybe get them in, say, we really need a power of attorney and a healthcare directive, but take them to an attorney and make sure when you're there that the attorney covers those topics.
I think it's also important to talk with, family members about kind of like what they picture the next phase of their life to be, as an icebreaker, as a conversation starter.
Right.
On top of, talking about this presentation, but I know from my own personal experience with my own mother, it was a multi-year process of, planting the seeds and working through the whole care need.
Yeah, I mean, and if it's helpful, I mean, I get called on to do these presentations several times a year, which are wonderful. I've done them for, the aging in place programs in certain towns. I've done them for, church, congregations. So, I mean, I guess I would look around and maybe see if you can find a trustworthy presentation to bring them to that doesn't cost them anything and they can just listen. And if it starts setting off red flags for them, then that might encourage them to want to go to the next step. Financial
advisors probably can also help start this kind of conversation.
Absolutely. I mean, depending on the level of I mean, most
expertise.
Financial advisors are pivoting to become more holistic, and they are talking about estate planning, especially financial planners who have that, kind of gone through a certain
certified
level.
Financial planners. Yeah.
Right. And there actually was a really good question asked in the chat about, once the home goes into the irrevocable trust, how do you deal with certain logistics? And there was a question that came up in the what you had gathered for me, Linda. If the property goes into a trust, as far as who can mortgage it, only the trustees can. So like if I move my house into a trust with my kids as the trustees, they're the ones that would have to take out a mortgage. And sometimes banks can be leery and even not do loans to an irrevocable trust. I think eventually you'd find somebody to loan on that. And I've had clients that had success with that. But yeah, if it goes in, you can't then get a mortgage on it yourself. It would be the trustees that would do it. The other thing that kind of commonly comes up is, well, what if I put my house into the irrevocable trust and later on down the road, I want to sell it and move and buy a new house down in North Carolina, for example. I've had clients do that. What happens is the kids, the trustees, they sell the home. The proceeds from the sale of the home here in Maine comes into the trust. The kids turn around in the trust and they buy the new house down in North Carolina in the trust. So you don't lose that 5-year look back period that you started years ago, and you still end up with a new home. We do a new life lease to the parents, or some type of tenancy agreement so that they have the right to live in the new house in North Carolina. And that's how they work through that issue. But again, a lot of this planning, Linda, really is for people who trust their children, care very deeply about wanting to move assets along to the children. It is not planning for the clients. So when clients come in, I say, this isn't benefiting you other than the peace of mind maybe that you've passed assets on to the kids. So I counsel heavily to people, making sure they understand that they're giving up something. They're giving up control. They're transferring an asset that they can't readily pull back. And that's something I really try to get through in the consults with them.
So somebody doesn't really care if they leave anything. I mean, it's their money, it's from their work. I mean, and they just will, like you said earlier, do nothing. So whatever comes along, use down your assets to the point. And if you outlive them, well, then you've got Medicaid as the backup.
Perfect example. I had a client years ago, and I was appointed by a court to handle her affairs and her assets. And she had, a couple $1 million and didn't really have any close family. And we just spent every last cent that we could to fix up her house and to private pay for care. I mean, I was paying $20,000 every 2 weeks so that she could have 24/7 round the clock nurses, because otherwise she would have needed full skilled nursing care. But she was able to stay in her home and pay privately and fix the home up and do all sorts of things for her to make her life better. And some people, that's all they want. They don't care necessarily to pass assets along to their children. It's not their primary goal. And if it's not your primary goal, you can just do your traditional estate planning, have a will, a power of attorney and a healthcare directive, and say, hey, if there's anything left after I'm gone, I haven't spent it all, then it goes to you. But otherwise, I want it for me. I want to make sure I'm taken care of. I worked hard for this. So that's certainly one side of the spectrum of clients that come in. And for those people, I say, great, now that you don't want to do anything. And for every client that comes in that wants to do something, I have another client that doesn't want to do anything. So it's not something I put any pressure on. I just say, here are your options. You tell me where on the spectrum you want to be.
You have to be careful when you're looking for like some kind of independent living, assisted living, transition care kind of place. Not everyone is only going to be private pay.
Right.
They won't let you start by private pay and then transition to Medicaid if it ends up going that way.
And there are some really truly wonderful services that are available. Some of them even free to the individual. One that I'm aware of that I really have referred some clients to, and they've loved the process, is Coastal Transitions of Maine. And it's two lovely ladies that have been in the business for a long time. And what they do is they help the families go around and review the various facility options that are available to them. So don't feel like you have to do that search on your own. There's plenty of awesome resources available to help you shop around and drop in unexpected, or that will give you the skinny on that particular facility that you don't know just going there and dropping in for a visit.
Thanks very much, Miles, for sharing your information and insight. It was very helpful.
Thanks for having me, and thanks for attending, everybody, and happy to help out if anybody needs to connect.
Great, thanks. Have a good night, everyone.